This is Tom Howe from the Legal Technology Group. In your litigation response plan, you should set forth the litigation history at your company. In the litigation response plan, you would review and summarize the litigation that's occurred at your company the last few years. How many legal matters have you addressed? Usually companies break down legal matters into two types. There's litigation cases where a lawsuit's been filed, but there may be other files that some corporations call red files or risk files, where litigation has not been filed but there's a substantial risk of a claim. Of course, there are other types of matters such as regulatory matters. Document all of these in your litigation response plan and break down the claims as to plaintiff or defense claims. What type of claims does your company deal with? For example, maybe your company has 200 legal matters every year, 12 discrimination cases, 1 class action, 3 regulatory cases, and 112 product claims. By understanding what types of claims you have to deal with, it helps you better create the plan and respond to litigation. Next, review the litigation requests, the discovery requests that you receive for these cases. This means laying out the discovery requests on a conference table, examining them, and looking for common patterns. What are the most common types of paper documents requested, or electronic files or emails in litigation that you address? List common types of items to produce and specify the source and location of the electronic data. On this slide, you'll see a common request for production in the United States. A single request could involve many documents. So you need to catalog the most common requests. You see, lawyers, and I did this much over the years, you'll use common boilerplate requests. And when I work with companies, sometimes I'll see 70 or 80% of the requests being exactly the same. So why not expect those in litigation? For example, this request for production, it asks for CVs or contracts, and this request comes in quite often for that company. The name of the company, of course, has been changed in the slide. So now, if we understand the common requests for paper electronic files, we can do a couple of things. In some companies, we set up a central filing system where we put commonly produced paper documents for e-discovery. We limit access to just the legal department personnel, but now when a request for production comes in and they ask for that same contract or CV, we can just simply go to the file cabinet, pull out a copy of it, and we're done. We also suggest setting up a litigation server, or this could just be a file share on one of the company's servers. Again, only the litigation department would have access to this information. On that server, we would have a central repository of commonly requested or accessed electronic files that are commonly produced in your e-discovery cases. If you need help, please call the Legal Technology Group. We have experience helping corporate clients create litigation response plans. This is Tom Howe from the Legal Technology Group.